Good afternoon. My name is Emily Belanger with the Louisiana State Bar Association. Welcome to our Law Talks virtual workshop series. Today's Law Talk is on grandparents' rights, and we have attorney Vandana Sharpivedi with Acadiana Legal Services presenting on this important topic. So I'm going to get the PowerPoint. Okay. So before we get started, I need to go over a few important reminders. First, this presentation is being live streamed. Questions will be taken at the end, if time permits, and answered live. If you're watching at a library, you may walk up to the counter to ask or submit your questions to the library staff. If you're watching via Zoom, please use the Q&A section. And if you're watching via Facebook, please submit questions in the comment section. Please remember that all comments are public and visible during and after the presentation. Finally, please keep your questions general and not case specific. The attorney can provide information about the law and legal processes, but cannot give advice on individual cases. Please note that the information provided in this presentation does not and is not intended to constitute legal advice. Instead, all information, content, and materials are for general informational purposes only. No viewer of this video should act or refrain from acting based on information provided in this presentation without first seeking legal advice from counsel in the relevant jurisdiction. If you need assistance finding legal help in Louisiana, please go to the Louisiana Legal Navigator, and the link is listed here. The LSBA's inclusion of a program is not to be deemed a statement or an endorsement of the views expressed therein by the LSBA or any member of the LSBA. Speaker and LSBA programs were carefully selected for their knowledge, but neither the LSBA nor speakers warrant that the presentations or the materials were free of errors or will continue to be accurate. Statements in the presentations and the materials should be verified before relying on them. Opinions expressed are those of the speakers and do not necessarily reflect opinions of the LSBA, its sections, or committees. Views expressed are those of the authors and contributors only. So as I mentioned, our presenter today is Vandana Chaturvedi. She has a ton of experience with grandparents' rights issues. As you can see, she has a ton of experience just within the legal field on her own. She is currently working at Acadiana Legal Service Corporation, handling the family law unit there, which does a ton of work in the areas of divorce, custody, and the like. So without further ado, I'd love to turn it over to Vandana.
Good afternoon. Thank you, Emily. And it's my pleasure and my privilege to be here today and to be able to talk a little bit about the grandparents' rights in Louisiana. So starting off, I want to say that the Louisiana legislature, first and foremost, recognizes the parents' fundamental rights to take care of their children, to provide guidance and mentoring to their children. And in the event the parents are not able to do so, then the Louisiana legislature has given certain limited rights to grandparents in Louisiana. And as we all know, in the recent years, grandparents have stepped in to take care of their grandchildren increasingly more and more as time passes by. And today, what we are going to hear and what we are going to understand is how grandparents can step up and take care of the grandchildren, and what are the limited circumstances under which they can do so, and how to go about doing that. So, grandparents in Louisiana have limited rights, and these rights are mainly of three types. They have rights to obtain custody of their grandchildren. They have the right to obtain visitation, and they have the right to adopt a grandchild. And my law firm, Acadiana Legal Services, we only handle intra-family adoptions, and we do not handle agency adoption. So I will be limiting my presentation to the intra-family adoption of a child. And in this case, it would be a grandparent adopting a grandchild. And I do want you to understand that the rights of grandparents are not automatic. They need to be sought for in court, and they need to be approved by a judge. So without much ado, let's start with what kind of rights do grandparents have? So when it comes to custody, the rights that the grandparents have is to obtain custody of a grandchild, and it could be a joint custody or it could be a sole custody, just like any parent would would seek the court to award them either joint or sole custody. In a similar way, a grandparent can petition the court against the other parent to obtain custody of a grandchild. The other type of custody that they can seek from court is the voluntary transfer of custody. And this is something, it's a legal transfer of custody, which is filed in court, and the judge must approve it. And after that, they are able to get the voluntary transfer of custody. And we'll go into the details of each and every type of custody that I'm mentioning here. The other custody is the provisional custody by mandate, which is just basically by agreement between parents and the grandparent. And then the fourth type of custody is the ex parte custody that we are going to be talking about, which is emergency custody, which requires a petition showing what the emergency conditions are. So, all right, let's break it down even more and talk in detail about each and every one of these custodies that a grandparent is able to petition the court for or to seek otherwise. So, what are the grandparent custodial rights that they have for their grandchild? And like I said before, the first and the most paramount thing that the Louisiana legislature, their intent is that parents have the paramount right to custody of their child. And it is only when a parent is not able to exercise custody of the child in accordance with what the legislature has set out as the best interest of the child. And we'll go over the best interest of the child factors a little bit later. It's only when a parent is not able to do that, not able to provide things that are in the best interest of the child, that a grandparent has the right to seek custody. And they have the right to seek either a joint custody with the other parent, or they have the right to seek sole custody. And all of the factors that a court looks at for custody, they would apply to a grandparent in litigation for custody. So a grandparent may apply to court. By when I say apply, I mean file a petition to the court to be awarded custody of their child if the child is seen to be neglected or abused by the parent, and there are great concerns about the safety of the child, or if state or the Department of Children and Families, DCFS, has custody of the child. There's evidence of abuse and neglect by the parent, and the grandparent is able to show that an award of custody to either parent would cause a substantial harm to the child. And the other way a grandparent can get custody of a child, if both parents agree to give the legal authority and custody to a grandparent. So under these limited circumstances, a grandparent does have the right to seek custody of a child. If the parents are abusing the child, the grandparent may even file a protective order on behalf of the child and seek temporary custody. And we'll go into the details of that a little bit down the road. So what do the grandparents have to prove when they move the court to get custody of a child? One of the main things they have to prove is that the child has been living in a stable and wholesome environment with them, or if it's one grandparent, or that they are able to provide a stable and wholesome environment to the child. So that is the number one factor that the courts look at, that what is the capacity of the grandparent to provide a stable environment for the child. And two, of course, the grandparents have to prove why custody with the parent of the child is going to be harmful and may lead to, more neglect and more abuse of the child. So that is something that must be chosen. Okay, that must be proven. So moving on. So that is one way that a grandparent is able to get custody of a child. And of course, how it is done is you file a petition for custody in court, or if there is a custody litigation pending between both parents, a grandparent has the right to intervene in that case, in that pending litigation, as a third party that has interest in the custody of the child and is able to bring to the attention of the court how they may be a better alternative to either parent, or whatever it is that the grandparent is trying to prove to the court. They can only do so by filing a petition to intervene. All right. So that is one way. Let's move on to, hey, did y'all lose me? No, I'm here. The other kind of custody that a grandparent can file for is called a voluntary transfer of custody. And what that is it is a legal form of custody. It is a legal process whereby parents are able to transfer both legal and physical, or either or, custody to another adult, which in this case would be a grandparent, since we are talking about the grandparents' custodial rights. So what this circumvents is it takes away the need to file a litigation, or to have a lengthy litigation in court. The parents are agreeing and they are able to just provide to court their consent, and they are able to transfer custody to a grandparent. What is required is absolutely the consent of the both parties, which is both parents. And if one is deceased, then just one parent. It is temporary. It is not a permanent custody. It does require a petition, and it does require a hearing. And since it is not an adversarial process where one is going against the other, these hearings tend to go smoothly, and the judge has to approve it. And that is one way that the voluntary transfer of custody takes place. So what does it allow the grandparents to do? The voluntary transfer of custody. With that, the grandparents have the authority to obtain medical treatment for the child, take the child to doctor's visits, and have some authority over any kind of treatment that the child needs. It does allow them to have some authority to make educational decisions for the child, such as enrollment in school. But I am going to say this, that enrollment in school, do not take that for granted. You would need to speak, or check out what your school board in your district requires, because not all schools are going to accept a voluntary transfer of custody document for purposes of all kinds of school-related decisions. It definitely is recognized by medical providers, but for every school district, please do check with your schools. What it does for the child is, if the parents, for whatever reason, are taking some time out, they need to take care of themselves, they need, some kind of rehab or whatever it is, that it prevents the child from going into foster care. It prevents DCFS from coming in and taking the child. And it prevents any kind of a disturbance into the child's life when a grandparent is able to provide, a loving, stable, wholesome environment for the child. And it's easier for the child to be with a relative, such as a grandparent that they have known, than to be suddenly thrust into the state system. And it also maintains the parental rights where parents are taking some time out to take care of whatever it is that they need to take care of, and their rights are not being taken away from them, and they are not needlessly being dragged into court to appear and in at a time when they are not really able to do the best for themselves. All right, moving on. So this is custody type 2. So we will move on to provisional custody by mandate. That is another type of custody that grandparents are able to obtain. And what that is, it's just an agreement. The court does not come into it. It's an agreement between the parents and the grandparent, whereby a document is signed by the custodial parent that grants a grandparent limited authority over the child. This is a written document. It must be a written document, and it must be signed in front of two witnesses, and it must be notarized. But there is no mandate that it should be recorded in court. And there is this is extrajudicial. This is outside of the court. The court does not get involved, but it is an agreement between two parties, the parents and the grandparent. Its validity by law is for just 1 year. It cannot go over a year. And even within that year, a parent has the right to revoke it at any time that they want to do that. What does it allow the grandparents to do? What it allows is it authorizes medical care, treatment for the health and welfare of the child. A grandparent is able to take the child to doctors and to make available any kind of medical treatment. Enroll the child in school, and once again, we are not going to take that as an automatic right. We are going to check with our school district, with our particular schools, if they are going to accept that or not. It also gives the authority to the grandparents to discipline the child and to provide a proper moral guidance, supervision, any other kind of guidance that the child needs, and perform other acts as necessary for the child's welfare, for the child's home life, shelter, food, clothes, all of that. So that is number 3. And then we move on to the other type of custody, which is the ex parte custody. Ex parte custody, you all might have heard about it. It's called emergency custody. What is ex parte custody? It is a temporary emergency order granted by a court without the presence of the parents. It is filed in court to protect the child from immediate and irreparable injury. Immediate and irreparable injury are legal terms. These are these are terms that need to be proven in court. So make sure that you understand that you need to prove, if you're a grandparent, you need to prove to court that the child faces irreparable harm, injury, danger, if the custody was not given to a grandparent. It requires proof of harm. It is an order that expires within 30 days, and it may be extended from 30 to 45 days. It may be extended 15 more days upon showing the need for the continued emergency custody after the 30 days are over. What does it allow the grandparents to do? It ensures the safety of the child. It provides immediate short-term legal and physical custody. Generally, it allows visitation to the parents unless it is proven that visitation would endanger the child. Generally, it does not allow a grandparent within the 30 days that the order is good for to take the child and relocate the child to another location. And like I said before, it may be extended from 30 days to 45. It's a one-time extension that the court gives. So how does this work and how is it obtained? So a petition for ex parte custody is what is required, that a grandparent in this case would file a petition. They must include a form, and I did try to include that form with my presentation. So I don't know if there we go. So this is a form for which is good for all Louisiana that must be attached to the petition for ex parte custody. And this requires a showing that the grandparent who's filing for the ex parte custody is also verifying all of the allegations that he or she has made in the petition for ex parte. And I have read the allegations, and they are true and accurate to the best of my knowledge. And they have to also put down the immediate and irreparable injury that they think will result to the child, named in the attached petition before the blah, blah, blah. So, yes, please. This is the form that needs to be included with the petition, and you need to list the reasons why you think that the child is in immediate danger, and if not given custody, the child will face irreparable injury. What it needs is a petition, the form, and it needs a rule to show cause, which is basically a hearing scheduled by court in which the grandparent will appear and will put their case before the judge to show what proof they have, why the ex parte custody needs to be granted or awarded to them. It also requires an attorney certification, and if you do not have an attorney, it is a certification for your own self that says that you have made every effort to notify the other parent. And if that other parent has been notified, you're going to provide proof to the court, or you will certify why notice is not required to the other parent, where the danger to the child is so extreme that the court needs to give this temporary emergency custody without notifying the other parent. So that's another kind of custody that a grandparent is able to obtain from court. All right, so that is part of the custodial rights of grandparents in Louisiana. Then the other kind of rights that grandparents have are visitation rights. So this is without having custody of the child, where the child, stays with you and visit. You have an arrangement where the child comes and lives with you for 1 week, 1 month, alternate weekends, whatever. It is not like that. It is just grandparent. And once again, I reiterate, it is grandparent visitation. And I must reiterate that Louisiana law, it respects parental authority first and firstmost. A fit parent has the fundamental right of privacy to raise their own child. And if that parent is not in agreement with the grandparent visiting, the court does not have any authority to say otherwise. So, grandparents' rights are limited to protect the parents' rights to make all decisions involving their child rearing. The basic and central test for awarding visitation to a grandparent is the best interest of the child. And the grandparent may petition the court to be able to visit with the grandchild, and a court may grant the grandparent visitation if one or both parents have died or incarcerated or declared incompetent. If parents have been divorced or been legally separated for 6 months, then a grandparent does stand a chance to get visitation. If the parents have never been married and are no longer living together, grandparent visitation is possible. Or any other kind of proof of extraordinary circumstances. And I can give you some examples of what constitutes extraordinary circumstances. It's substance abuse by the parents, potential for harm to the child, any other kind of neglect or abuse, or any other concerns that a grandparent has knowledge of. And of course, it will need to be proven to court because visitation is not automatic. So, and the grandparent also has to prove that there is an existing relationship between the grandparent and the grandchild, and that, of course, it is in the best interest of the child. Now, this limited privilege, limited right of visitation also extends to step grandparents, and again, under extraordinary circumstances. And if parents are married to each other, then grandparents have no automatic right to get visitation. How are they going to get visitation is a petition is required, either a petition by the grandparents to seek visitation, or if there's a custody litigation pending between two parents, then the grandparent has the right to intervene as a third party and become a party to the litigation. So what is the main point here is a grandparent or non-parent has the burden of proof to prove why visitation is in the best interest of the child, and a fit parent has the utmost fundamental right to control the visitation with the grandparent, and a parent can actually deny, and the court will have if the parent is a fit parent with nothing, no substantial allegations against that parent, a court has no authority to grant visitation over and above the parents' wishes. And what happens about visitation in an adoption case? Grandparents can get limited visitation if their child, which is basically the parent of the child, is dead and grandchild has been adopted. And again, best interest of the child prevails. So let's move on to another kind of right that the grandparents in Louisiana have, and that is intra-family adoption. So that is a right that a grandparent can exercise. And who can adopt a grandchild? A grandparent, a step parent, a step grandparent, a great grandparent, and just a grandparent. What does it require? If the parent's rights have been surrendered or terminated, a grandparent can move for intra-family adoption. If the grandparent has had physical or legal custody of the child for the last 6 months, they're able to move for intra-family adoption. If the parents have failed to provide financial support for the child, if the parents have failed to communicate with the child, and if it is in the best interest of the child, an intra-family adoption can move forward. What does it require is, it requires a petition. It requires a petition. It requires a consent to the adoption by the parents. It requires an act of surrender of the child by the parents. Or if the parents' rights have been terminated, parental rights have been terminated, if the parent did not provide financial support to the child, and the grandparent has petitioned the court for intrafamily adoption. And in that process, how does that process go? So when a grandparent has the right to file a petition, and what must be included in that petition is either a consent of both the parents or termination of their parental rights, the document that gives the judgment that has terminated the parental rights. Background checks are made from the local sheriff's office. The DA is party to the petition for intrafamily adoption because the DA's office is in charge of running the criminal background checks on the grandparents to make sure that there's nothing in their background that will prohibit them from being the adoptive parents of this child. What it requires also is a home study, which is conducted by DCFS, and to make sure that the home that is being provided to the child and will be the child's home after adoption is actually an appropriate home and has an appropriate living standard for the child. Now, a parent's consent or termination of parental right is absolutely necessary. If a parent is there but not being able to be located, and there's no consent on the record, then a curator would need to be appointed in place of the parent. Otherwise, the proceeding cannot move forward. However, if the father's identity is not known, then there's no need to appoint a curator. And one thing I would like to add that as legal service attorneys, when we practice intrafamily adoptions, is one type of petition where most courts in Louisiana will not approve an IFP. Excuse me. So make sure whenever you're filing an intrafamily adoption petition to check with the clerk of court if they will accept an IFP or not. And the reason for that is that the grandparents who are interested in getting the child is the only party that really has the interest in the child. The parents have either walked away, they're not around, their rights have been terminated, or so the court does not have an adversarial party to recover costs from. So they will expect costs to be paid upfront. All right. So we've talked a lot about all of the bases for the legal rights to a child, or the legal rights of a grandparent to a grandchild, are all based on the best interest of the child. So what are these best interests of the child? They are actually statutorily required. The legislature has actually defined what these rights are, and here we go. We are going to list them. What is the best interest of the child? It is found under Civil Code Article 134, potential for abuse, love, affection, and other emotional ties, capacity, disposition to give love, affection, and spiritual guidance, and to continue education and rearing of the child. Capacity, disposition to provide food, clothing, medical and other material needs. Length of time in a stable environment for the child. Permanence of custodial home. Moral fitness of each party. History of substance abuse, violence, or criminal activity. Mental, physical health of each party. Child's home, school, and community history. Child's reasonable preference. Willingness to facilitate a relationship, to foster a good relationship between the parents. Distance between residences. Prior caregiving by each party. So this is the balancing test that the court undertakes. No one factor outweighs the other. Each and every factor is as important as the other. And this is the basic framework which constitutes the best interest of the child. So, grandparents who are looking to either get custody, to get visitation, or adopt their grandchild in Louisiana have many resources available. And I know that Emily will go over the resources after I finish the talk. There's also financial assistance that is available to the grandparents, and it's called the kinship care subsidies. It's also the SNAP benefits and FITAP, medical and health services. So there is help available if and when grandparents are in need of that. Then there are resources in the community for grandparents to seek out in case, they're interested in any of these programs, or they're interested in obtaining custody or visitation. And these are, well, first I want to say Acadiana Legal Services, we are in 42 parishes of Louisiana, and we offer intra-family adoption services. We do custody and we do visitation. So we are a number one resource, and then Southeast Legal Services, which handles the other remaining parishes in Louisiana, they do the same. And Emily, I will hand it over to you to talk more in detail of resources and to just take over from here.
Yes, thank you, Vandana.
Sure.
Um, okay, so as you can see
And
here, we
then
have a
we can
couple.
take questions after that.
Yes, thank you. So as you see here, we have a couple resources listed. The ones on the left-hand side, the community resources are non-legal, and they have some interesting resources for grandparents that are thinking about or looking to either file for custody or visitation with their grandchild. A couple different pathways that you can do that, some support services, a couple group meetings and things like that. So please take a look at those services if that's something you're interested in. And then on the right side of your screen are your legal services, like Vonda said, Southeast Louisiana Legal Services. They provide free civil legal assistance across Louisiana's southeastern parishes. So think of Orleans, Jefferson, St. Tammany, and then Acadiana Legal Service Corporation provides free civil legal services again in Louisiana's western and northern parishes. So Lafayette, uh, Alexandria, Shreveport, Monroe, those areas. The entire state is covered by one or the other. So you can check out their websites to see which legal service corporation you should reach out to based off of where you live. Okay, I'm going to check for questions. So if you have any questions, now is the time to put them in the chat or to put them into the on Facebook. Um, I don't see any questions at the moment. So while we wait for questions, I want to highlight some additional resources. These may be helpful if you have a legal question that was not addressed during this presentation or you need help getting assistance. This is a flyer for the LSPA's Find Legal Help page, where you can access a continuum of resources. It includes our attorney directory, the Civil Legal Navigator, legal aid and pro bono organizations, the Modest Needs Directory, and self-help services. I'd like to call special attention to the Louisiana Civil Legal Navigator. This is a great diagnostic tool that helps you identify your legal issue and provides customized information, referrals to legal aid, and more. It is simple to use and will give you next steps specific to your issue and or your parish or location. You can also access Free Legal Answers, which is an online pro bono program that allows users to log in whenever and wherever they like and ask civil legal questions and have attorneys answer those questions through the site. It is private and acts almost like an email exchange between the user and the attorney. Please note that users must meet certain income guidelines to use this program. All right, let me go back and see if we have any questions that came up. Yes, no. Okay, we do not seem to have any questions, but I'll we'll just sit here for a few minutes just in case anybody's
No problem.
typing it in. Question coming through. See it typing. All right. Can grandparent custody be reversed if false statements are proven? If it's proven that false statements have been made?
Absolutely.
Wonderful, thank you.
It would require, well, it's case by case. And if grandparents obtained custody by fraud and by unlawful means, then absolutely.
Do we have any other questions?
So I would just add that custody is never cast in stone. It is always fluid and it depends on the change in circumstances, best interest of the child, and any person who has custody of the child, be it a parent or a non-parent, has the right to move the court to prove best interest of child.
All right, well, I'm not seeing any more questions. So I will go ahead and keep going. All right, so that concludes our Law Talk workshop for today. Please save the date for our next Law Talk on public benefits. It'll be held June 9th at noon. Thank you so much, Bonita, for presenting today. And thank you to everybody who attended. I hope you have a great rest of your day.
Thank you, Emily.
Thank you. All
Bye-bye.
right, see ya. Bye.